377-407. We have Mr. Arnold appearing for Mr. Davis, who's present in custody. Additionally, we have Mr. Giacomo and Mr. Bilal for the state. This is on for defendant's motion for reconsideration and reinstatement of previous bond. It's also on for a status check discovery. And then I think the state could also file a counter motion for me to reconsider my ruling that there was not proof evident presumption. Great. Accurate?
That's correct.
All right. Mr. Arnold, your motion to reconsider and reinstate bond, I voided the bond on 6/24/24, so there's no bond posted. What is there to reinstate? How would that even work?
Really vacated the bond. The bond bailsman, who I believe is on the line, said that the bond was still posted. If it's not, we can repost it immediately, but I don't believe it, because the language that you use, it never came off, so they still have the actual
So it went
bond.
back to them, but ultimately they haven't returned it to the person who posted it.
Correct.
Okay. So did you want to be heard any further then on the motion?
Yes, Your Honor.
Go ahead.
First, I'm going to do argument and then also take testimony from Cash. Do you want me to use this, Your Honor?
That is
No.
media.
Oh.
Basically,
Actually, Mr. Arnold, if you, because the last one that I typed, if you could stay at your table, because
Oh, okay,
they have
this
the
is
same
not-
mic as Cash,
Oh, okay.
so if I can separate them, it's easier if you stay back.
Great.
Thank you.
Go ahead.
Thank you, Your Honor. Again, Your Honor, looking at the first comments that you made at the initial source hearing, on page 3, you said the purpose of the source hearing was to ensure the bond was not posted with proceeds when talking about the murder or killing of Tupac. There was no evidence at that source hearing that Mr. Davis was paid any proceeds for the murder of Tupac. He has been paid in the past through a book, through social media accounts, etc. The only evidence that we had at the source hearing was a prospective payment. And Mr. Jones was very adamant that there was no contract between those two yet. And so it was prospective in regards to his life story. The state made comments in regards to, well, the only thing that people would be interested in regards to his life story is basically in regards to Tupac, and that's simply not true. I mean, Mr. Bilal has read the books as well as I have. His life story, he was one of the most notorious gang leaders of all of Southern California. He ruled Compton. He was the godfather of Compton. Basically, he had a drug trade that extended from here to New York to Little Rock, Arkansas. He was doing 350 kilos at a time with the Mexican cartel. There's many aspects of his life that are relevant and interesting to the community other than the death of Tupac Shakur.
A lot of my initial ruling really focused on the sufficiency of the documents and proof ultimately that this was not obtained through illegal sources. It was because the documents gave me so many questions about where those wire transfers came from, where those counter deposits came from, $50,000 deposited at counters, and typical, what we're seeing. Additionally, when you go into his drug history and things like that. So we're really looking at, is this a bond that was posted through legitimate sources? And
Right.
so that's why I was looking more into the bank records. And that's really the first part and the largest part of my ruling. I mean, I have
Okay.
concerns ultimately about the profiting off of Tupac's death, but I think my authority is somewhat limited
Right.
to, in the source hearing, to determining whether it's legal or illegal.
Right.
And so
in Your Honor, in regards to...
you gave me the June records.
Right.
The bond premium was wire transferred out on June 11th. I see a transfer in right before that of $112,000 and $500 wire transferred in on June 11th and then immediately taken out in 2 separate payments. You provided me a check to show a portion of the payment, and the rest was, I do see wired out in the records. I don't see that check that you provided me even coming out of the bank account.
It has not yet, Your Honor. And again, we have the, Mr. Jones and the bail's bond on there. What they had agreed to was pending Your Honor's ruling, he was simply going to hold on to the check, which there's funds in the bank to cover that check.
Okay.
But he was gonna hold on to the check until the court approved, the ruling and then go ahead and cash it.
So my question ultimately is, where does that $112,500 transfer come from?
Right.
Because given your client's own words, Mr. Jones was a front or a middleman for this money, and so ultimately if I know who that came from, that would give me more peace of mind.
Right, and we did provide the court with the actual company that the check came from. And that was the Agent Entertainment Touring Group. And you can see that notation in the June 11th transfer out of the bank. It says AG Entertainment Touring.
Okay.
Now this is a client of Mr. Jones. Mr. Jones would testify that he received this money, this was money owed to him. He asked for that specific amount of $112,500 on the basis that he knew that he was going to use that money to pay the bill. They owe him more than that, but that was a payment that they made to his account.
Okay, anything else?
And so in regards to whether those monies came from a legitimate source, I think you have all the information there. We have a legitimate bank account. We have a legitimate business. He received the funds from another legitimate business. Your Honor can even review their website at www.agententertainment.com. It's a legitimate transaction between 100 Entertainment and AG Entertainment Touring. And he decided to use that money. In regards to any restrictions that money is for his life story, again, as Your Honor just noted, it's very limited that at this point, since he's not convicted, you cannot tell Mr. Davis he cannot receive those monies. He can receive any monies in regards to this crime until he's convicted. That's well supported by the Nevada case law. It's supported by the statute that the state had previously alleged that they were relying upon, which was 41B200.
Which case law specifically?
No, they didn't mention any case law, but I'll get to the case
Okay.
law. But I was just saying that the state referred to 41B200.
Sure, the Slayer statute.
The Slayer statute, which says it has to be a convicted killer. But the case law that we are referring to is the Sears v. Lerner case. Let me get you the site.
Okay.
That's 120 Nevada 930 2004. In that case, it was a discussion in regards to the statute NRS 217.007. That statute was found to be over-inclusive.
Can I
It's
get that site again? Did you say
Yes.
120 Nevada 930?
930 2004.
Nothing comes up. Nevada's for Nevada versus Beers? The only thing that's listed.
Sears v. Lerner. Sears is SERES versus Lerner. I could double check the site for
Okay.
you. But again, in that case, it was discussing NRS 217.007, the court found that statute to be over-inclusive. And that statute was the right of a victim to receive proceeds from material based upon or related to a crime. The reason why the court found it over-inclusive was because it did not restrict the realm of possible defendants to just convicted felons. Additionally, in that case, in the Sears case, I believe on page 939, excuse me. On page 939, the Nevada Supreme Court cited to the United States Supreme Court of Simon v. Schuster. Simon and Schuster, discussing the Son of Sam statute in New York, voided a provision which denied the recovery of proceeds from telling a story by any person who has voluntarily and intelligently admitted to the commission of a crime for which such a person is not convicted. So basically, the United States Supreme Court threw out a statute on the basis that a person can admit to a crime, but if he's not convicted of the crime, he can still reap financial benefits from that crime. Sears also upheld that in their decision to find NRS 217.007 as over-inclusive. The constitutional analysis that has to be made in this case is a strict scrutiny analysis, because basically with that court's ruling that he cannot benefit from the proceeds of talking about the murder, there has to be a strict scrutiny analysis because it violates his freedom of speech rights. And for there to be a violation of freedom of speech rights, the courts have said in a strict scrutiny analysis, number one, the state has to state a compelling interest, number one. I couldn't figure out what the state's compelling interest is in this one. But mostly I was thinking it was probably because of the victim, but I'll leave the state to go ahead and address that. The victim's being compensated. I'll let the state assert what its compelling interest is. But then after it asserts it, we have to see if the court's ruling order is narrowly tailored to go ahead and affect that outcome. And we don't believe it is, because basically at this point, what we have derived from the court's ruling is he cannot talk about his life story, which he can. The only victim, because Mr. Shakur has no living heirs at this point.
So to analogize this to another constitutional right, for example, freedom to associate.
Mhm.
I can, as a condition of bond, I can restrict someone's ability to contact, for example, the victim or children under 18 or things like that. And so as a condition of bond, in order to meet those two goals of bond, ultimately the court has greater discretion in fashioning release conditions. And so I think ultimately, to cut to the chase, that's the state's argument, is that this is a condition of bond. And the argument that they have is that this is a condition of bond similar to that. And so it's not a situation where, a family member or somebody is posting the bond to ensure the safety of the community, or to ensure that he comes back. And so really the conditions of bond are not met, or the ultimate goals of bond are not met by Mr. Jones posting this one.
Right. And the argument that they presented now was that the condition of bond is that the court has stated is being used to protect the community. Because obviously it's not to ensure his presence. There may have other things to ensure his presence, house arrest and the electronic monitoring. But to protect the community has already been exposed to his life story. They've been exposed to his different recollections of what occurred that night. The community is not being harmed in any way, fashion whatsoever by him telling his life story.
I think the harm is probably more future criminality or injury to potential witnesses, as was argued at first, than the community being exposed to the story.
But again, all of that has been discussed in regards to his different videos that he's done, to his book, that has been discussed. So there's no additional harm that can be done. What I think would be a better order by the court, if I may recommend such, is that there be a gag order on Mr. Davis from having any conversations in regards to Mr. Tupac. It should not be publicized, printed, disseminated in any fashion until after the conclusion of the trial. This whole order that prevents him from being able to collect money, like I said, it's an infringement on his right of freedom of speech. It drags us down a quagmire that we don't need to be dragged
But if I'm
down.
entering a gag order, isn't that implicating those exact same rights that you just asked me not to?
Right, but I think it's narrowly tailored because, again, remember how I started off, that Mr. Jones wanted a 10-part series. That 10-part series, I would imagine one of the episodes in that 10-part series would include the Shakur slaying, but there's many other things and interesting life events, crime stories, etc., that Mr. Davis can discuss. And so, do you see the distinction, Your Honor? The life story and just discussion in regards to Tupac Shakur.
I mean, I've read so many things, I don't know if they're true necessarily, but it seems like your end goal here is to make some sort of show on the prep for this trial, according to news articles that have been sent to me.
Like again, you read so many things about it. That's not my
Your quote to the Sun is not accurate?
That's not my end goal here, Your
Okay.
Honor. My end goal is to win the trial. Okay. Whether they want to follow me with cameras, they can do that. Are we going to benefit by that? I promise you, as an officer of the court, we have not signed a contract, nor have we been given any financial incentive to do something like that, Your Honor.
Okay, this case isn't going to be your legacy. Okay, you may continue, Mr. Blum.
Yes, Your Honor. So, just to focus on what this court actually ordered. So the court may reach two orders. This is a motion to reconsider, right? So to bring it back to what this court ordered, the first finding of this court was that the defendant failed to make a prima facie case that the funds were from a legitimate source. Your Honor, first I would suggest that a preponderance is probably state would suggest a preponderance, but even if we were using prima facie,
And I'll let you know why I went with that, because ultimately there was some disagreement. We don't have a statute
Right.
for source hearings. There was some disagreement among the states of what the standard was. And as you know, prima facie is much lower than
Yes.
preponderance. And so ultimately I used the lower standard, so ultimately it would be encompassing both standards. I honestly, would welcome some guidance on what the standard should be for this hearing, because I'm sort of flying blind on this thing, but at the same time, that's ultimately why I fashioned that. And so I understand your argument,
Yeah.
but ultimately that was something I did consider.
But yes, and what I think is very telling, though, is that after taking evidence, sworn testimony from Mr. Jones and Mr. Davis, the defendant couldn't even make the lowest threshold of prima facie case that this came from a legitimate source. So, and the reason still remains true. Defendant's statement to his wife that Mr. Jones was a middleman, I think this court really has to consider. Also, as we provided exhibits, it wasn't just some spontaneous lie that he told his wife, as was proffered to this court at the last source hearing. Instead, these schemes, these plans, these attempts to deceive the court have been going on for months and months, laid out on jail calls over and over. Hey, we're going to use this person as a front. We'll use that person as a front. This person doesn't want to testify, so we've got to get somebody that will testify. And the sample I gave to the court is just that, a mere sample, mere sprinkling of the scheming that has been going on by Mr. Davis in order to deceive this court as to where the source of the funds come from. And so, the other point I make is Mr. Jones lacks any credibility whatsoever based on the evidence that we've heard. Your Honor, I would go so far as to say that he perjured himself. And the reason why is, let's look at the evolution of Mr. Jones's positions. The letter he offered this court is, this is a gift. And I've known Mr. Davis for a long time. We're good friends for a long time. Then his testimony evolved. It started with when Mr. Arnold asked him, are you receiving any benefit? No, I'm not receiving any benefit. Then it goes, when I ask him, well, is there a contract? It evolves to, well, there's no contract yet. Then when Mr. Arnold asks him about, well, on the jail call, we did hear about a contract. Can you tell us about that? And then Mr. Jones tells an incredible story about what they're actually discussing. It has nothing to do with the murder of Mr. Shakur, but it's about a car that Mr. Davis once held, and he needs to get the title cleared. So that's what he's talking about signing. So, and then this court tried to clarify what Mr. Jones was saying. And Your Honor, you have the transcript. You tell me if you got anything from Mr. Jones's response, because I sure as heck couldn't figure it out. In fact, it's the reason why we asked for the transcript is because, well, maybe I'm not understanding and something meaningful was said. No, it was just nonsensical rambling. And so that's just what happened in court under oath. Now we take the extra court, outside of court statements. We have a jail call that refers to a contract. We have a YouTube interview where he talks about stipulations. We have a Clubhouse interview or a Clubhouse social media post where he talks about, hey, I just received this contract, and as a result of this contract, I'm going to be bailing Mr. Jones out, or Mr. Davis out. And then after the hearing, he goes another YouTube interview where he tacitly admits, yeah, so what if I got this from somebody else? What if I told somebody, hey man, I need $112,500 in order to make something happen, and you'll get it back if I can get that money back. That is a remarkable admission that he makes after this court hearing. And Your Honor, whether or not, and I'll address whether or not the legality of the court's requirement, but whether or not Mr. Davis or Mr. Jones agrees with the court's position, they are not allowed to, one, lie, attempt to deceive the court, or two, scheme on jail calls to circumvent this court's rulings. So I don't know what Mr. Jones could tell you that would give this court anything, prima facie, preponderance, anything, to believe that this is from a legitimate source, given Mr. Jones's observable willingness to deceive the court in order to get his deal done. So Mr. Jones has no credibility. Mr. Davis has no credibility when it comes to this, except though I do appreciate Mr. Arnold admitting, conceding that Mr. Davis is a notorious gang leader, that he was the godfather of Compton. I appreciate those admissions, but if anything, I think that should go to the later argument that Mr. Giacomo is going to present, that maybe this court ought to reconsider its positions, given these concessions today. Mr. Arnold's position has always been, you can't trust Mr. Davis because he's not telling the truth. Well, apparently he is telling the truth about being a godfather of Compton, and he is telling the truth about being a notorious gang leader. So, Your Honor, the source of the funds, at least for Mr. Jones, is just not credible. He is not a credible source. Anything that comes through him is not credible, is not reliable. Now, with regards to whether or not the court's has the ability to set conditions on a detention order, I think first and foremost, this court made a finding that a detention order was necessary, right? It wasn't that we're just setting bail. This court found, after a lengthy briefing, lengthy argument, given all the factors required to be considered in NRS 178-4853, that a detention order was necessary to protect the public from Mr. Davis. And so, one of the conditions for release was that he may not benefit from Tupac Shakur's killing, right? He may not use proceeds from that to make his bail. And I would submit that this court was correct in doing that, because pursuant to NRS 178-4851, subsection 3, this court can set any condition without limitation as long as it relates to keeping the community safe. And Your Honor, I would argue that a person publicly availing himself of funds from the proceeds of a murder that is still awaiting trial is in fact putting the public in danger. After all, when we were here in January making this argument, one thing the state told the court and reminded the court was that the FBI literally had to move a witness based on credible threats from the defendant. Now we are going to infuse him with more funds from proceeds from killing Mr. Shakur. How does that keep the community safe? It certainly does not conform with this court's finding that a detention order was necessary to protect the community. I would also add, Your Honor, that a gift, even if we were to believe Mr. Jones's original story out of the 4 or 5 he told, even if we go with the original letter, this is a gift, Your Honor, that simply does not meet this court's findings that Mr. Davis presents a danger to the community and requires to be detained. Because the only reason why you set a detention order assured by a monetary amount is because the philosophy that, well, he has at least got some incentive to follow the court's orders based on the monetary penalty he will suffer if he violates this court's rulings, right? Otherwise, there's no point to the cash bail, to the set of bail. And so if he's just being given found money, $112,500, just because, if we were to believe, again, Mr. Jones's first story, just because he's a gift, he's a great guy, I've known him forever, even that, I think, would undermine this court's findings of a detention order being necessary. But that's not what we have here. Lastly, Mr. Arnold, with regards to the First Amendment, what's curious is that Mr. Arnold suggests a gag order which actually does trigger the First Amendment violations that he worries about with the bail, the release restriction. Because a gag order actually does require a strict scrutiny analysis. But a condition of release does not require a strict scrutiny analysis. And as this court aptly pointed out, every court in this courthouse restricts whom a released defendant can associate with, right? And we have that freedom of association, but you can make it as a condition of release as long as you tie it to the safety of the community or the ability to return, or the likelihood to return. And here, Your Honor, there is a close tie to funding somebody because of their retelling of the crime that they are on trial for and the safety of the community, especially given what we know about Mr. Davis being as Mr. Arnold pointed out, a notorious gang leader and the godfather of Compton gangs. Your Honor, given those concessions, this court ought to be concerned.
A lot of what Mr. Arnold argument centers on, ultimately in his pleading papers and a little bit of what he's talked about today. We are pre-trial. There's the presumption of innocence at this point. And so, how does the state address that, given that these aren't convictions?
Right.
These are, his story is what got us here.
Right.
And his story, now he's saying, is a total lie.
Right.
And everything that he said is a lie.
Right.
And so, how does the state sort of reconcile those two issues, those two?
Right, and so I guess I made an overly nuanced argument with regard to 42B last time we were here. My point with regards to 42B...
I understand, you can't get the money back.
Yeah,
Once it's gone, once it's posted, it's gone.
Okay. So then if we just go back to the presumption of innocence, sure, Mr. Davis is presumed innocent. This court was aware of that when it set its orders in January, and that's why we had a whole hearing, and this court created a detention order and a requirement based on the well-considered factors listed out in NRS 4853 about the danger to the community Mr. Davis posed. That's the reason why. That is the reason why he should not be able to profit from talking about his crimes, not because of 42B But because this court made a finding that he's a danger to the community, and one of the stipulations of his release tied into his danger to the community is that he should not be using funds from the murder of Mr. Shakur to fund his release. One other thing I just want to clarify for the record is that Mr. Arnold stated that Mr. Shakur has no heirs. He does. I believe Miss Shakur, his sister, is on the line. His brother also. They run his estates, and so I just clarification, not for the point of our argument, but just for the clarification purposes. I want to acknowledge them because they've been involved very much through this whole process. But yes, Your Honor, presumably when this court made that order, it made the finding, because this court laid out specifically all the factors, the couple for Mr. Davis, a number against Mr. Davis, and then made its ruling that he should not use those proceeds. And I would assume that's because this court believes, as the state believes, that using funds from the proceeds of the murder does not protect the community.
Mr. Arnold, did you want to respond to any of those points before I move to the state's counter motion?
Yes, Your Honor. Specifically, it seems that this is not a matter of protection to the community or ensuring his presence. What the state is asking for Your Honor to do is simply that my client not make any money off of this case. There's no legal authority that they have cited to that disallows my client from making money on this case. Right now, his son, myself, even he can enter into a contract with any media entity and make money on this case. The court cannot prevent him from doing that, and no one has access to those proceeds until he is convicted on this case. That is just the law. And so why is a bail condition going to his ability to make money? Next, the state says, well, this is a gift, and so there's no repercussions. There's probably been 80 people bailed out this morning. Most of it is a gift, Your Honor. It's going to come from the mother, the father, the spouse at times. A lot of people are getting gifts to pay for the bail.
If my mom bails me out, I don't want her to lose her house.
Right.
If some guy that I think is a front and a bad dude, his words, not mine, bails me out, I don't really care if he loses his money. And so that's, I think, my big concern with that point. I mean, there's other concerns.
Right, but that individual, Mr. Jones, he has recourse against Mr. Davis should Mr. Davis flee or not show up to his court appearances. But he has no reason not to show up for his court appearances, for the simple fact is that's part of the story, Your Honor. That does not make sense.
Talking in circles here. So it's both about, his life story is not about the Tupac murder, but also it's only about the Tupac trial. Is that what you're saying?
No.
Because that's his reason for coming back.
What I'm saying is, Your Honor, the life story of my client is separate from the murder of Tupac.
But the only thing that drives him to come back to court would be that he can only profit from a deal if he's either convicted or not convicted or goes to trial in some way. That's just what you said.
No, that's not what I meant.
Okay.
Because the reason why he's coming back is to find himself not guilty on this case. He has plenty of incentive to come back. He's not going anywhere, and you have set the parameters to make sure we know of his whereabouts at all times. That ensures his presence.
Okay.
Additionally, you said in regards to a Nebia hearing that you needed guidance. Many of Nebia hearings that we've done on the federal level as Assistant U.S. Attorney, what we were trying to determine is whether those funds came from an illegal source. Did they come up from some made-up corporation? Did they come from a legitimate bank account? Or there are records to indicate that this was a legitimate business? Those were the factors that we were trying to get from the source here.
Right, in
And
federal court, but we don't have any sort of statute or case that says anything about what our source hearings look like.
Right, but we do have those concerns met in this instance. That is, we have a legitimate business, number one. We have a entity, 100 Entertainment, that has been in business prior to the beginning of this case. We have another entity, AG Entertainment Touring, that was in existence prior to the beginning of this case. They made payment to 100 Entertainment in the amount of the bail. Again, for reasons known to Mr. Jones, he asked for that specific amount, and there's nothing illegitimate that the state has pointed out in regards to that transaction. And so, since there's nothing illegitimate about that transaction, that satisfies the requirements for the Nebia hearing. Him being a notorious gang leader, that shouldn't deter the court from allowing him to be free. He was a notorious gang leader in 2008. Those days are long gone. He was a law-abiding citizen for many years here in Las Vegas. And so he should be able to go back and again tell those stories. We are not protecting the public from anything. What we have to do again is to make sure that he's going to be present, number one, and that number two, that the community is going to be safe. He has not violated the law in any way. He hasn't put out a hit. We don't know the validity of this FBI moving a witness and how that witness was going to be in danger. There's no indication that Mr. Davis has any power with any gang or any people out there to go ahead and order a hit or anything like that. And so those are all speculation by the state and should not be considered in a Nebia hearing, which should just be the focus: do we have legitimate sources?
Okay. State, did you want to be heard regarding your counter argument?
Yes, Judge.
On motion, I apologize.
And I'll be brief as it relates to that.
We can start changing circumstances.
Yeah, there has been a significant change in circumstances. You know, obviously the state disagreed with the court's prior ruling, but I think there was probably two reasons behind it. One was, look, there's a number of statements by the defendant, but what exactly is the corroboration? And then the other one is one I don't quite grasp from a legal standpoint, but the temporal relationship between the arrest and the crime, right? That 27 years, kind of something about it. But when you look at our motion to reconsider, there's only one temporal relationship that really matters, which is in 2006, there is a live witness who puts the four people the suspect says in Las Vegas leaving to go harm Suge and Tupac Shakur. That witness is corroborated by records from a hotel that establishes he was here, and we know that he's a member of this gang. But the most important temporal relationship here is he makes that statement 2 years before any confession the defendant ever made. And that's the reason why I put the 2008 in there, and I know there may be some litigation about what exactly that 2008 statement may or may not be used for. But certainly in 2009, when he makes a fully admissible confession to those facts, he puts the same four people in the car that an eyewitness has him leaving a bar to go harm Tupac and Suge on the night in question. So now it's not just a guy who's confessed 37,000 times to killing Tupac Shakur. You now have corroboration long before he ever said that from a witness that he wouldn't have known would said that gives the exact same factual pattern. And I suggest to you, there are a few cases where you can get a full confession and not have the proof as evidence presumption is great. I understand why in this case the court probably had some reticence. But now that we know that there is a live witness that places Mr. Davis with the three other suspects leaving to harm Mr. Shakur, long before he ever confessed, the proof has to be evident and the presumption must be great at this point, and I would submit it to the court.
Can you just answer for me why this wasn't presented at the bail hearing?
I can't. We didn't have these records. There was, I don't want to say a lack of cooperation necessarily from law enforcement in other jurisdictions during the course of this, but this has been a highly complex situation involving Christopher Wallace, the lawsuits, and getting those records. Ultimately, we just received, as I put in the motion, we just received, between the time of the last bail hearing and the time of this court, this particular hearing, we just received an enormous amount of records that we supplied over to Mr. Arnold from the Christopher Wallace investigation. And this report was within those thousands and thousands of pages that we had. And then we went out. There are other confirming people, but the only one we can establish that this witness is currently still alive at this point is this particular witness. There are other things that fully corroborate the story that Mr. Davis said long before Mr. Davis ever said them. It's just at this point we have not yet confirmed that we have a live witness that can actually testify to it. And I put that in the motion as well.
Okay. Mr. Arnold?
I didn't understand that last part. We're talking about Corey Edwards, right?
That's the
Yeah.
witness that we.
All right.
That's
And he's
within
not
this-
alive?
He's alive.
Okay. And so, in regards to Mr. Mr. Edwards, again, gave a statement in 2006 that he identified the 4 people that were in the car and he identified them in Vegas. That is not a change of circumstances in regards to this case that was under the meaning of the Nevada Rule 7B that the court can reconsider its bail. Basically, all he did was corroborate what has been said by Mr. Davis in his multiple interviews and by the state in their presentation of the case. And so a corroborating witness, that happens all the time. It shouldn't cause the court to go back and review its bail. Mr. Edwards, he's not reliable. He made this almost 10 years, this statement 10 years after the incident. And so, bottom line, he could have heard that through hearsay, rumors. I don't know how he came up with this information, but that's subject to cross-examination at the time of trial, and it shouldn't be considered here to look at the bail again. Again, as you stated, Your Honor, he has a presumption of innocence. We should be allowed to discuss that presumption of innocence at the time of trial, but still, we can't just shirk it aside for the sake of this statute of Nevada that allows us to look at this presumption. You already made your decision on that, and we ask that you abide by that decision and remember that my client is presumed innocent.
All right. Excellent arguments on both sides. Ultimately, this is a little bit more wide-ranging, especially from the defense perspective, of what was covered in the briefing. So there's a couple things I need to look at before I issue an order, okay?
One last thing, Your Honor, I apologize. Someone provided me with the site. It was 102 Nevada 928. I apologize.
I did find that one.
Oh, okay.
So thank you though. Thanks for looking that up. All right, I'll let you guys know the next day or two, my opinion, or my decision regarding both. Thank you. We talked a little bit about discovery. Anything else you think that Christopher Wallace discovery seems pretty wide-ranging?
I think we have turned over everything. We do have one last thing that was turned over to us that we need to review. I don't think it has anything relevant to Mr. Shakur's murder. It involves a totally different case, but I just want to, and I've gone through about 2/3 of it, haven't seen anything that we need to disclose, but I'm working diligently to make sure that even through this unrelated case file, it was turned over to us, so I want to go through it and personally make sure that Mr. Arnold has anything that would be exculpatory or inculpatory.
Okay. Mr. Arnold, how are you progressing toward that November 3rd trial date?
I'm concerned about this box. I just want to see it. I mean, we just got the box, the Greg Keating box that he was talking about. We're going through it. We should have our review done before the end of the summer. I'm just concerned another box comes and we have to do further investigation on that.
So as we sit right now, you'll be ready for that date because I have a death penalty case trailing.
Can I say 30 more days and then make that
We'll do a
determination?
30-day status check then on trial readiness, and then it'll be,
That'll be August 20th and
Now address the court.
I think we're done.
I got something to say.
You wanna say to Mr. Arnold, and he can say, he represents you, so ultimately you represent yourself, you can talk at will, but if somebody
Mr.
represents
Greg
you.
Keating had them boxes at his house for 15 years in his attic, doing all kind of TV interviews. That them boxes should not be allowed in a
He's
case.
just gonna talk about it.
Yeah, them boxes should not be allowed. The tainted evidence, everything. The man, he broke a proffer agreement, and he broke the law, all kind of stuff. The boxes should not be allowed. They've been at his house for 15 years, and he's doing interviews, going in the boxes. Let me see here. Ooh, you can see it on any internet site that this man been going in the boxes for years, and he's let them go. And a judge, federal judge in LA, did a 142-page thing about him. Look it up on the internet.
So I think what the state said ultimately is that they don't think there's gonna be anything in those boxes that they're gonna use.
You just use something in them boxes. They just used something in them boxes from 1996, and they know they did it.
Yeah, no, it's certainly we are.
They're not only ugly on the outside, but they're ugly on the inside. They crashed my family in this. They did my daughter first. They did my son. Then they just did my wife the last year. What's the name told me about these? David Westbrook told me about these dudes. He said they're not only ugly on the outside, but they ugly on the inside too. These two dudes right here.
Alright, at this point, there's nothing before me to exclude any sort of evidence. There's been no motion filed about the proffer. I don't know if Mr. Arnold plans on challenging that or not. Ultimately, that decision is up to him. So we'll see you guys back on that 30-day date.
that was August 20th at 9 a.m.
Or at that time, we need to know if we're gonna go on the 3rd.
Thank you, Your Honor.
Thank you. Alright, page 7.